Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today we're going to look at what a typical estate plan might look for someone who is in pre-retirement and beyond. Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or follow along on my social media. I'm at Amanda Rocha Law. So if you are pre-retirement age, getting there, in the next few years, or you are just retired and you're trying to figure out whether or not you need an estate plan, or whether you need to update your current estate plan, or what kind of estate plan you might even need, I'm going to give you a few common examples that I see in my daily practice, or that I'll prepare for people who are in this situation. So before I get into any of that again, I just want to preface this by saying every person's estate is different. So this isn't by no means advice on your particular estate, but typically what I will see is people that age who have grown adult children who do not have an estate plan yet are usually concerned about making sure that their children are basically given what they want to give them and their grandchildren are taken care of. Or if they have no children, they want to make sure whoever their beneficiaries are will get what they're supposed to get. And usually there are a couple of main concerns here. One, avoiding probate, which everybody should be worried about doing, and it's very simple to do. Two is they want to make sure that their retirement accounts are not affected by their estate plan. And lastly, they want to make sure that death or estate taxes are not going to be a problem for them. So I'll take it step by step. First, making sure your beneficiaries are taken care of. It doesn't matter what your age is. If you have any property at all, regardless of how much it's worth, you want to make sure it goes to who you want it to go to, whether that's children, grandchildren, cousins, sisters, friends, whatever. An estate plan allows you to do that. So with a will and a trust, those two tools together or separate, you can name where your property goes when you pass away. But not everything will avoid probate that way. So a will is directly submitted to the probate court. If you have assets that value more than $184,500, and those assets are probate assets, meaning they are not joint accounts with another person, they are not beneficiary style accounts, and they're not in a trust, then they're going to count towards probate. If you put those in a will, simply just a will, probate will not be avoided. The will is submitted to the judge reviews your will, your executor goes through the probate process on your estate's behalf. If you didn't have a will, it would still go through the probate process, except your executor would be called an administrator, and you don't get to choose who your administrator is. The court will decide that, and you don't get to choose where your property goes. The court decides that based on lots of different rules and practice and procedure. So if you care about who gets your things and whether or not they're going to have to spend 2 years about to get them and money to do it, oftentimes many thousands of dollars, then a trust, a revocable living trust, is a great tool to put something like a house in during your lifetime and afterwards. So if something were to happen to you and you became incapacitated and your house was in your trust, then your trustee could step in when you're incapacitated and handle all of that property in your trust during your lifetime. And afterward, instead of filing a trust with the probate court, they are just able to handle it outside of court and pass it along to whoever you want it to go to without having to deal with 2 years of court procedures and thousands of dollars. And another thing about a revocable living trust is that it's not going to affect your ownership of your property. So you still get to control it in the same way that you would have controlled it before the trust, and you get to add things to it, remove things from it. You can make as many changes as you want during your lifetime. However, the downside to a revocable living trust as opposed to an irrevocable trust is that the revocable trust does not protect your assets from creditors, and it does not protect them from Medi-Cal. If you think that you're going to need Medi-Cal in the future, and I'm not talking about for prescriptions, I'm talking about for healthcare, whether in your house or you need to go into a facility and be cared for and you can't afford it. There are look back periods and things that you have to worry about as far as that goes. So Medicaid asset protection or Medicare asset protection trust used to be something that we recommended. Now with a bunch of laws changing in that area, I'd say it's going to depend on your situation. So reach out to an estate planning attorney in your state. If you're in California, you can call me and we could talk about what your concerns are directly with that. But other reasons that an irrevocable trust might be right for you are tax avoidance. If you have an estate worth more than $12.92 million in California, then you'll want to try and do some things to avoid estate or death taxes, because that is the threshold that you'll have to meet. So if you have an estate that large and you're looking at different trusts and what you can do, certain assets can be put into an irrevocable trust, and those assets will no longer count towards your total towards death taxes or estate taxes when you pass away. If your estate is worth less than that, most irrevocable trusts are tax avoidance or asset protection trusts, sometimes special needs trusts. Other than that, most people are looking at revocable living trusts. And the other thing I wanted to mention is retirement and what to do about it. Most people do not put their retirement accounts in their revocable living trusts. They keep them separate, and as long as your beneficiaries are listed and up to date, you should be good with that. Definitely speak to your attorney about specific kinds of accounts, but having a revocable living trust will not affect your retirement in any way unless you tie them in together on purpose. So if you have any questions about any of this, please feel free to reach out to me. You can schedule an appointment with me on my calendar, which is on my website. That's at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or follow along on my social media where you can send me a message. I'm at Amanda Rocha Law. Thank you.